The important thing to understand about the trial is it will all come to nothing if you haven't done your preparation. Okay, so really the critical thing is to have actually done all your preparation. Civil litigation is about paperwork. It's not about eloquent advocacy at trial with cross-examination of the witnesses, persuasion of the judges and the courts. It's actually just simply about making sure you put all your arguments down, you produce all your witness statements and exhibits nicely, you've filed and you've served it on your opponent, so your opponent has it, the court has it, you've done all of that well in advance, and you turn up at trial and you've even made contingency arrangements for the incompetence of the court potentially, or errors, or not necessarily incompetent. Courts are very understaffed, so you've done everything you can to eliminate errors, right? And you know, a lot of hearings, the judge is sitting there and he hasn't got the full set of papers. So, particularly if you're the claimant, you should be driving the litigation and you should be making sure everybody has all the paperwork, yeah? Because otherwise you might adjourn the hearing, that's just a whole waste of a day. So, that's the first thing to emphasise, is proper preparation of your paperwork. There you go, you can even give yourself a little acronym, PPP. Staple it to your forehead, stick a post-it to your forehead, tell yourself proper preparation of my paperwork in the mirror each morning you get up during the course of these legal proceedings. That is critical. If you then go into court for the trial and everybody has got everything, then you're just emphasising points, addressing questions. Okay, there may be some cross-examination. The judge in a small claim where you're not represented will do some cross-examination of his own, so you don't kind of in a way have to worry about being a brilliant advocate. You just need to, and if you do, if you have got some critical questions, just make sure you've listed them down on a piece of paper. I would just simply make sure on one piece of paper you've any key points that you want to emphasise, you make on a bit of paper, perhaps 5 max, and then maybe if you have got some questions you want to ask opponents' witnesses, then you have some more papers in order to do that, or you mark up their witness statements, because you'll be going through their witness statement as you're examining them or doing cross-examination. But don't worry too much about all of that. The main thing is that you've got the paperwork in front of the judge. Hearings and your opponent, don't forget. Don't be trying to be clever and make it difficult for your opponent, yeah? Make sure, where it comes to management of the case, you've just got to be completely neutral and responsible and make sure your opponent has everything. Turn up with additional copies at the court, if necessary, especially if you think there's any danger that the court might not have certain documents, and check that the judge has got the documents that you need to take him through. All right. So usually a small claims trial is half a day or 2 hours. A fast track claim is usually a day. It's going to take longer, become a different type of claim. Now, as far as a small claim is concerned, there's no special process in terms of the hearing. It's the same judge as there would be for any type of case, and it's the same court, and it'll probably be in his chambers, so it'll be more informal. It's very unlikely in a small claim to take place in a big courtroom. It'll be just in the judge's office, basically, with you on one side and your witnesses, and then your opponent on the other side. Okay, so really that's all there is to it, in brief. He may give judgment there and then, and he may adjourn, and judgment may come later as a hard copy. Okay. Finally, it's really important to turn up with your costs. Okay. People, and lawyers included, are notorious for forgetting about preparation of their own cost schedules. Okay, if you have incurred costs, court fees, experts' fees, travel expenses, even legal fees, put them on your cost schedule. Now, in a small claim, I say even because in a small claim you're not entitled to your legal fees even if you win, unless your opponent has behaved unreasonably. So because of that little caveat, you should always turn up with being prepared to argue for your full costs. Yeah, and if the judge finds in your favour, the next thing he will come on to is the issue of costs. So make sure you've got a clear breakdown of what your entire costs in the case have been. Nice and clear and short and simple. There are templates, but you don't have to put it in a formal template. But just make sure it's nice and clear. And probably best to sign and date it as well, so the judge knows that you are declaring that's an official document, and those are definitely the costs that you've incurred in the case. Now look, I think something like 5 or less % of claims actually come to trial, so it's more likely than not that you'll get nowhere near trial. But I'll just finally emphasise the 3 Ps. Proper preparation of your paperwork is absolutely critical, and make sure that everybody has copies.